So today, for my brief hour, I thought what we'd do is talk about 3 questions. And I'm not going to lecture. I'm going to call on you. We're going to run it like a law school class just to make sure you don't go. But what I'm going to do is ask you questions. If you don't answer them, then I'm going to start calling on people randomly about the reading. And if you hadn't done the reading, I'm going to start making fun of your parents and your family, which is traditional law school incentives to do the reading. So it's best if you volunteer and answer the questions rather than, because I don't know if you do think about going to law school, watch this movie, The Paper Chase. I don't know if you ever heard of it or seen it, but it's still the way I teach class in the Socratic method. And so we're going to have to resort to that if we don't have enough participation. So 3 things I'd like to talk about today is, 1, why do we have a Supreme Court and how did it come, why do we give it so much power to decide the most fundamental questions in our society, right? Gay marriage, affirmative action, the role of religion in public life. Even just this last term, who's going to get to decide the congressional districts in a state? What kind of questions are we going to be allowed to ask on the census? Even these questions are decided by the Supreme Court. So first question to ask is, how did we get to this point? Why do we give the Supreme Court that kind of power? Should we? Second question is, once the Supreme Court has this role, if you're a justice on the Supreme Court, and there may well be one of you in here, although you have to go to Harvard or Yale Law School, apparently, because all 9 of the justices now either went to Harvard Law School or Yale Law School. And from the Kavanaugh hearings, as far as we can tell, had a really good time doing it. Just as a side note, I was at law school at the same time as Brett Kavanaugh. Actually, when he graduated, I took over his apartment, and I looked under his bed and in the cupboards, and I didn't find anything either. But all I remember him from law school is that he played a lot of intramural basketball for the whole 3 years that I saw him there. Senator. And then the second question is, so what kind of method should a justice, if you were on the court, use when they address a question that the Constitution doesn't clearly set out? And then the third one, I thought would be fun, let's maybe apply those tools to some hot button topics like guns or abortion. How do you interpret and answer the question, does the Constitution guarantee an individual right to have a firearm? How far can the state go? Right, I didn't assign this knowing that these things would be happening in the world today, but how far can the government go in requiring background checks or even banning certain kinds of weapons? Same with abortion. Does the Constitution protect an individual right to abortion? How far can the state go in regulating or even prohibiting certain kinds of abortion? So that's where I'd like to go today. Okay. So first off, let me ask, why do we have a Supreme Court? Why give it this kind of power? Let me contrast it with Great Britain, from which we draw a lot of our political and legal traditions. Great Britain, until very recently, never had a Supreme Court. They didn't even have a written constitution. Most major questions of social policy, like the kind we're talking about today, were decided by Parliament. Still are today really decided by Parliament. It's only since 1945 that other countries have started copying us, introducing the idea of a Supreme Court that answers these great questions. For most of history of these sort of industrialized countries, it was usually the legislature, the elected people's representatives, who answered these questions. So why do you think we should have a Supreme Court do it? Why don't you, to make it easy, why don't you stand up and say your name? If you talk a lot, everyone already knows your name by now anyway, but remind me.
Hi, my name is Winston Zhu. I just graduated from Vanderbilt University in May.
That's all I want to know about you. Okay.
Got it. So to answer your question, I think there are kind of 2 reasons I would offer. Mm-hmm. First, because we have what I would call a two-tiered systems of law. The Constitution is the supreme law of the land, mm-hmm. and then you have all the other legislative laws by Congress, mm-hmm. state laws, local municipality laws. And So the Constitution trumps all of that. So therefore, it might make sense to have a specialized group of people looking at the Constitution, who know what the Constitution says, understand these precedents, understand what the Constitution even means, to go about deciding, okay, what does the Constitution actually have to say about this issue?
Good. Sit down. That was very good. 2 reasons. Very good reason. One is you have a Constitution and you have regular law. The Constitution is supreme law. Everyone agrees on that. Even in Britain, where they don't even have a written Constitution, they talk about a Constitution and principles that are superior to everyday law. Right? That's certainly true. Their second answer, though, doesn't necessarily follow, but is what we believe, or a lot of people believe today, which is if you have that superior constitutional law, you should have a group of specialized, trained people who are interpreting it. So, right, all 9 justices of the Supreme Court, I think it's always been the case that all the justices of the Supreme Court have always been lawyers. 8 of the 9 justices today were lower court judges, right? They were judges in what we call the circuit courts of appeals. The 9th judge was a Solicitor General, who's the representative of the executive branch before the Supreme Court. These are people who spend their whole careers thinking and learning about law. But why is that necessarily the case, that we think those people should be picked to interpret the Constitution? Do you think that Congress doesn't think about the Constitution when they pass a law, or that the president doesn't think about the Constitution when he or she signs or vetoes a law? Yeah, oh, wait, you had your hand up first, right here. Yeah.
Hi, Kayla Webb, Wellesley College. The Supreme Court kind of decided for themselves that they were going to do this in Marbury v. Madison.
Yes.
Sometimes it's referred to as the Revolution of 1800, I think, where they basically wrote in their own decision that they needed, and not that they needed, but that they were exercising judicial review. And
Why? Why? So my question is, you're completely right. In Marbury versus Madison, the most important Supreme Court decision in the court's history, it's 1803. The court says, we will have the power to strike down day-to-day laws that violate the higher law of the Constitution. Why does the court say they get to do that?
The closest I can remember is that they were saying that it's implied by the history of the Constitution itself.
Which hadn't been around that long, right?
No.
So what is that history? No, that's very good. So what is that history that, let me ask you one more question. What is that history that it was?
I mean, I don't know if that's referring to the Articles of Confederation or British law or what, but history of the Constitution was the closest I could figure out.
Yeah, no, that's good. So this is exactly what Chief Justice John Marshall says. He doesn't say quite what you say. He doesn't say judges are better at it. Right? That's sort of your argument. That's what a lot of people today, naturally the Supreme Court justices think that too. They're just better at it, when actually we all know it's the law professors who are better at it, because we got better grades in law school than they did. There's this funny joke, if you get law school grades, if you get an A, you're going to be a law professor. If you get Bs, you're going to be really rich, a partner in a law firm. If you get Cs and your roommate is a senator, you're going to be on the Supreme Court. Yeah. It's actually true empirically. I can prove it. Josh Rao will prove it to you empirically with data. So, right, you're a very good point, though. It's not, Marshall never claims the Supreme Court should review laws that we pass today against whether they're constitutional because judges are smarter or better or well-trained at the law. Right? In fact, the Constitution, does the constitutional text, did Marshall say the constitutional text said the court could do it? No. Boy, you're going to shake your head off. You're shaking your head so hard, no. Right? The other thing that's implicit in both these points is, unlike a lot of constitutions in the world, this Constitution, our Constitution, doesn't say anything about judicial review, anything about the Supreme Court being allowed to strike down laws or executive actions. It's silent, and so it was implied. So then, if it's not about expertise, there's a reference to history. What other reason will we give for the justices? Yeah, all the way in the back. Yeah, you had your hand up third.
I'm Shekinah from Georgia Tech, and I think it really relates to the framers wanting to have a separation of powers in our system of checks and
Good.
balances.
Love it. Lay it out.
Okay, so each branch has its own set of powers, and the purpose of having a judicial branch is to be this kind of neutral third party that can adjudicate issues when.
Oh,
they
you
arise.
lost it. No, that's the modern explanation. Very good. No, keep going. Sorry. I was just getting too excited. Go ahead. Keep going.
No, I was almost done, actually.
Okay.
So.
Or so you hope. But go ahead. So you say we have a separation of powers, and so you want to have this neutral branch. Why do we need the neutral third branch? Why does it even have to be neutral?
Right. So the whole idea was that they're not beholden to any political agenda or a certain ideology, but their only goal is to protect the integrity of the Constitution and ensure the supremacy of the Constitution.
Right. So this is, if you were to ask a lot of students of the Constitution today, this is the answer they would give. Not because the judges are better trained or care more about the Constitution, but the idea is that they're more dispassionate, less involved in politics, and we need some third party that's not the president, not the Congress, and not the states to decide on disputes. So how is it that we know these justices are neutral third parties? I mean, isn't President Trump today saying, I appointed conservative judges, love me for it? Right? How do we know that the judges are these neutral people?
Well, I don't think that we can just because they're appointed by presidents who are pretty partisan, but I think that having another check where they're nominated by the president but have to be confirmed by the Senate was created to kind of counteract this or ensure more
And how long do they get to stay on the court?
Forever.
Forever. Even after they die, they still seem to
Well, okay.
linger on. Yes.
Until they retire or if they get removed.
So they have lifetime tenure. What about their pay?
I don't know the exact amount, but it's a lot.
It's a lot. Actually, it's not that much. If some of you go to law school and then you graduate in your second year after law school, you will make more than a Supreme Court justice. And who says the markets aren't efficient? Right? So, but the point is, the pay can never be reduced, right? And they can be impeached, but they serve for good behavior. In fact, if you think about how often do presidents serve? 4 years. How long do senators? 6. And 2 for members, and they have to come up for re-election. Justices, that's the dispassionate ideas. They are removed from politics. Maybe they got there. Partisan president, partisan Senate, gives the advice and consent. But once they're there, they are not responsible to anybody, right? As you say. So I think that is sort of the modern view of why we give these powers to the Supreme Court, because at least let's have a neutral third party to decide it. That was not the view that Chief Justice Marshall set out in Marbury, though, interestingly.